and is a senior legal fellow for the Religious Freedom Institute. The Federalist Society's 15 practice groups are organized by substantive areas of law. Each practice group is led by a chairman and executive committee comprised of top lawyers from across the country. They meet each month to organize in-person events, webinars, publications, and the panels for the Federalist Society's flagship event, the National Lawyers Convention. You can learn more about the practice groups at FEDSOC.org/practice groups. On the topic of practice groups, Ms. Lichter, can you describe some of the work that your particular practice group does?
Sure, I'm happy to do that. Thanks, Michael. So I'm on the executive committee for the Religious Liberties Practice Group, which is a great practice group, I have to say. It's large and it's very active. And one of the best aspects of our practice group is that the membership includes a really good mix of practitioners and academics. So you have theoreticians, and then you have folks who are busy representing religious institutions in regulatory proceedings and in litigation and in-house like me. Several of us have previous government experience, which provides another helpful perspective. And we've got all the big religious liberty shops represented, ADF, Beckett, and First Liberty. So like all the practice groups, we do the things Michael mentioned. We plan and host events, both in person, like at the convention, and virtual, and we contribute written content to the FEDSOC blog. I'm the publications chair for our practice group, so I spend some time haranguing people about writing for the blog and other FEDSOC publications. But because so many of us are actively involved in representing religious orgs, like I said, we also have a really robust sort of internal economy, I guess I would say, in terms of updating one another on developments in the field and occasionally sharing action items like requests for amicus support or a heads up about an open comment period on a regulation. So I have found it to be a really good and useful group in the sense that it's both interesting and helpful for me professionally.
Yeah, no, absolutely. I mean, that sounds like it's just a great network of information to be a part of.
Yep.
I'm certain many of our student viewers would probably like to know, were you a member of the Federalist Society while you were in law school?
I was. I actually became informally involved with FEDSOC even before I went to law school because I am lucky enough to have a father who's a longtime Federalist Society member. So my dad is a law professor at Notre Dame Law School. He was the chair of the Religious Liberties Practice Group for some years. And I went to the National Convention with him the year after I had just graduated from college, but before I had even applied to law school, actually. I attended part of the convention with him and got hooked. So yes, when I got to Harvard, I joined FEDSOC on day one, probably technically before day one. And I had various roles during my time in law school, including I was the vice president for speakers for our chapter. I was the articles editor for the Harvard Journal of Law and Public Policy. I had a role in the Abigail Adams Society, which is Harvard's conservative and libertarian women's organization, sort of a sister org to FEDSOC. When I graduated from law school, I stayed involved. I tried to go to events whenever I could. There were a few years where I couldn't afford to go to the annual dinner, to be perfectly honest, but I would still go and listen to convention panels and try and drop in on other events to the extent that I was able. Then I was invited some number of years ago, a while ago, to join the Religious Liberties Practice Group, which has been fantastic. I had to leave it when I joined the government about 5 or so years ago, and then I rejoined the practice group when I came out of the government.
That's awesome. That's funny. The apple really doesn't fall far from the tree with you and your father, and then you were able to get out and come back.
Yeah,
it seems relatively flawlessly. So that's an awesome story. I hope to emulate something like that after my graduation.
That's right.
So before we get started with the substantive part of tonight, I'd just like to remind everybody that you can make use of the Q&A function. We'll try to get to as many of your questions and get as many answers to you as we can towards the end. I think this discussion would probably benefit from looking at it from two angles. First, looking at the relationship of the higher education as an employer, and then looking to something that our student viewers are probably be more familiar with, the university-student relationship. So starting with the university as a higher ed employer, could you give some insight into what that relationship looks like in the legal world and what current issues are going on regarding that?
Yeah, thanks. Yes, I'm happy to. So I'm going to share, talk about a couple of issues in this category that I'm particularly tracking, again, as a practitioner and in my role working as a lawyer at a religious university. The first one is the ministerial exception. And what does that look like in higher education? I suspect a lot of you know what the ministerial exception is, but for one else who maybe haven't run into it yet, I'll give you some quick background, and then we'll talk about what that looks like in the higher ed context. So what's the ministerial exception? This is a doctrine derived from the First Amendment that's been teased out by the Supreme Court in just 2 key cases so far at the Supreme Court level, and that's Hosanna Tabor in 2012 and a case called Our Lady of Guadalupe versus Morrissey Beru in 2020. So the ministerial exception, according to the Supreme Court, provides significant autonomy to religious institutions in the hiring and firing of their employees who are, quote, ministerial, meaning basically employees who have vital religious duties or who play a key part in carrying out the institution's religious mission. It's rooted in the First Amendment, like I said, and specifically rooted in the First Amendment's protection of the right of autonomy of religious institutions to make their own internal governance decisions. When the ministerial exception applies, it's super powerful. It completely forecloses employment discrimination claims from being brought against a religious employer by a covered employee, in other words, by a ministerial employee, even if those claims are not based on religious discrimination specifically. So in other words, a ministerial employee, an employee who's judged to be a minister, cannot bring claims of discrimination based on age, disability, or other protected traits against its religious institution employer. So then, as you can imagine, a really important question is, well, who's a minister? Who's a ministerial employee? The Supreme Court has emphasized that whether the employee is called, quote unquote, minister is not at all dispositive. Instead, the Supreme Court says you have to look to a bunch of different factors, including the title, yes, but also including the employee's training, how they hold themselves out, and their job duties in particular. And in the more recent case, Our Lady of Guadalupe, the court really leaned hard on that final factor, moved away even further from looking at title and said what really matters is what the employee does as it relates to the religious mission of the institution. So the 2 key Supreme Court cases so far, Hosanna Tabor and Our Lady, both involved elementary school teachers, and again, at religious schools. And again, in both of those cases, the religious schools won. In other words, their employees were designated as ministers and their employment discrimination claims were blocked. But it is not at all clear yet what the ministerial exception looks like in the context of higher ed. And you can imagine that it might look different because typically a university, a college or a university, is a little bit more of a, you might say like a shaggy enterprise than a Catholic elementary school, right? Or a Lutheran elementary school like in Hosanna Tabor, where it's just a more sort of tightly controlled employment setting, right? And a university is founded on academic freedom, right? And its employees are partly governing the university if they're faculty members, right? Faculty have some governance rights in some places. So it's a very interesting and difficult question. Earlier this year, the Supreme Court had an opportunity to tease out how the ministerial exception in higher ed might look different from the K-12 context, but the court punted on that. This was a case involving Borden College, which is a Christian college in Massachusetts. It denied promotion to full professor to a member of its social work faculty. The school said it was because of her lack of scholarly productivity, right, which is a perfectly fine reason to deny someone tenure, deny someone full professorship. But the professor says, no, it was actually because of her vocal opposition to the college's policies regarding LGBTQ individuals. This case went up in state court, not in federal court, and the highest court in Massachusetts held that the teacher was not a minister and that her discrimination lawsuit against Gordon College could go forward. So then the college came to the Supreme Court and asked the court to determine if the ministerial exception barred this suit. The court denied cert, it seems for procedural reasons. It thought the case wasn't ready for review by the Supreme Court. But Justice Alito released a statement joined by Justice Thomas, Kavanaugh, and Barrett, saying that the Massachusetts court had taken what he called a troubling and narrow view of what religious education is. The Massachusetts court had said the teacher wasn't a minister because she didn't teach religion or really anything related to religion. Again, she was a social work teacher. Justice Alito says, well, religious education can include much more than just instructing people in religious doctrine or in theology. You can teach all sorts of secular subjects through a religious lens. And he suggests that maybe that's what religious colleges and universities are doing. So that was a short statement. It was just signed by 4 justices, so obviously doesn't have any precedential authority, but it's a good indication that the Supreme Court wants an opportunity to look at the ministerial exception at the higher ed level. So what could that tip of the spear case be at the Supreme Court? Justice Alito suggested that Gordon College itself would be welcome to come back to the court with another cert petition once it was procedurally appropriate to do so. I'm also watching a case that was brought against Liberty University, a Christian university in Virginia, by a former art teacher. That case is making its way through the lower courts. Liberty lost in the district court. The district court held that the art teacher was not a minister. The case is now teed up at the Fourth Circuit. Briefing is complete. My university is actually an amicus in that case, along with a number of other religious universities, because again, this is but even though it's not a binding case for us located in the DC circuit, it'll be a precedent-setting case in the sense that there just isn't a lot of case law yet on this question of the ministerial exception in higher ed. So it's up at the Fourth Circuit, no argument date set yet, but keep an eye on that case, which could also be the first to the Supreme Court, depending on the timing of the Gordon College proceedings. Second piece that I'm going to talk a little more briefly about in terms of religious institutions as employer is particularly important for religious colleges and universities who hold traditional, what you might say, traditional beliefs about marriage. And that question is, what does the Supreme Court's 2020 Bostock decision mean for how these religious schools interact with their employees who are in same-sex marriages? So in Bostock, as I think you probably do all know, the Supreme Court said Title VII's prohibition on sex discrimination in employment extends to prohibit discrimination on the basis of sexual orientation or transgender status. So the word sex in Title VII includes sexual orientation and gender identity. In that majority opinion, which was written by Justice Gorsuch, typically very friendly to the rights of religious individuals and organizations, the court explicitly acknowledged concerns that expanding the definition of sex in this way could require religious employers to violate their deeply held beliefs. And the court said it shared this concern with preserving free exercise. But it also said that question is not in front of us today. So we're not going to get into detail about what a protective framework for religious employers might look like. We'll just sort of flag that the ministerial exception exists and Title VII has a religious exemption in it. And the Religious Freedom Restoration Act might be helpful. But they said we're going to leave the details to another day. So courts are just beginning to figure out how Bostock's extension of protection under Title VII to sexual orientation interacts with these existing legal protections for religious orgs. One key case to watch that isn't about a higher ed institution, but will certainly be relevant to colleges and universities is called John Doe versus Catholic Relief Services, where one of the questions is whether CRS can decline to provide medical benefits, health benefits to the same-sex spouse of one of its employees because of its adherence to Catholic teaching about the nature of marriage. CRS lost in the district court in Maryland. The court said none of the legal protections that are typically available to religious institutions apply. They're briefing a separate issue right now, a post-decision briefing in the district court, but I expect this case will go up to the Fourth Circuit. And again, this is going to set a really important precedent for all religious institutions, including higher ed, in terms of what Bostock means and in terms of how religious institutions can relate to their employees.
Definitely. I had to read Bostock this week for my statutory and legal legislation interpretation class.
Yeah.
So I did have a question pursuant to Bostock, specifically Justice Alito's dissent. You know, he mentions that Congress had for years kind of contemplated bills to add sexual orientation and gender explicitly to Title VII, but they haven't done so. So he argues that by ruling in the way that the court does, they're legislating from the bench and kind of overstepping the boundaries there. You know, this sounds kind of similar to, I guess, a mainstream argument that was against substantive due process with the recent Dobbs ruling, that substantive due process gives too much power of the governance of the nation to the court as opposed to the elected branches. You know, obviously hindsight is 2020, but given that Alito wrote the majority opinion for Dobbs, should we have viewed this dissent as kind of a clue in for what was coming up? And either way, you know, how powerfully should a dissent like this be looked at going forward in terms of its weight?
Yeah, that's a great question, especially for a Federalist Society event, because I'm sure you know, Michael, and all the other student leaders on the call know the kind of three core principles at the heart of the Federalist Society, right? One of which is it is emphatically the province and duty of the judiciary to say what the law is, not what it should be, right?
Absolutely,
I recited that principle so many times at the beginning of events when I was in law school. I'm sure you have too. So great question. So I don't know that we should really kind of draw a direct line from Justice Alito's Bostock dissent to Dobbs, but it is certainly true that he and others on the court and many others in the conservative legal movement have long been skeptical of the concept of substantive due process, like you said. Interestingly, though, Justice Alito's Dobbs majority didn't reject substantive due process. He did note that the theory of substantive due process, protected by the 14th Amendment is, I think he just said it's controversial, or it's long been controversial. But then he went on to apply the court's substantive due process framework. He sort of went through the exercise, right, before saying, no, the 14th Amendment, under our substantive due process precedents, the 14th Amendment does not protect a right to abortion. But the real shot across the bow on substantive due process, of course, came in Justice Thomas's Dobbs concurrence, where he says that substantive due process is an oxymoron that lacks any basis in the Constitution, right? I'm sure many of you have read this. And then he kind of blows everyone's minds by saying that, in the future, we should reconsider all of the court's substantive due process precedents, including Griswold, which has established the right of married people to use birth control, Lawrence, right, the right to private consensual same-sex sexual activity, and Obergefell, the right to same-sex marriage. Of course, Justice Thomas is not suggesting that all of those things should immediately snap back to being illegal, but he does seem to be saying, while we're on the topic of substantive due process, like this is all bunk, right? So query whether others on the court would be willing to join Justice Thomas in this quest, but he certainly, in my mind, gets a lot of points for intellectual consistency, and his views need to be grappled with moving forward. So yeah, keep all of this in mind for sure, moving forward in cases that implicate the substantive due process precedents. And then, as you said, Michael, the question more generally about judges, shouldn't be legislating, right? They should just be interpreting the law, not making it.
Right.
Great question.
Yeah, no, definitely. I mean, Justice Thomas certainly didn't mince words in his in his opinion. Absolutely not.
Yeah.
So I guess kind of looking, like I said, as most of our student viewers will be more familiar with the university-student relationship. I know that the Hunter and the Yeshiva cases have been in the news recently within the past month or two, both. I'm a little bit familiar with them. I've read a couple articles, but again, I was kind of, you could provide some more context for these cases.
Yeah, sure. So let's start with the Yeshiva case, which, as you said, has been in the news this fall after Yeshiva decided not to officially recognize an LGBTQ student group. So this is a fact pattern that occurs at other schools too, and Yeshiva is sort of, again, at the tip of the spear case right now for what this relationship between a religious school and its student groups, its would-be student groups, looks like. Yeshiva, of course, is a great university in New York City in the modern Orthodox tradition. It was approached a couple years ago by a group of students who wanted to start a group. They wanted recognition for a group they called Pride Alliance. So they wanted a recognized LGBTQ student club at Yeshiva. The university administrators consulted with a group of senior rabbis who rendered their opinion that the university could not recognize such a club consistent with its religious commitments. And so Yeshiva declined recognition to the Pride Alliance, which then promptly sued them. In state court. So this is a state court, not federal court, bear that in mind. Yeshiva lost in state court on a ruling under the New York City Human Rights Act. And then that court, this New York court, ordered Yeshiva to approve the club immediately. Yeshiva appealed, but its appeals were rejected. So it made an emergency request to the Supreme Court, asking the court to stay this state court order saying, Yeshiva, you have to approve Pride Alliance. The Supreme Court declined to intervene, saying that its understanding was Yeshiva still had some recourse in state court and needed to sort of jump through some additional procedural hoops. But it invited Yeshiva to return to the Supreme Court if it couldn't get relief from the state courts. And Justice Alito, again, you might be sensing a theme, Justice Alito, who has a lot to say, joined by Justices Thomas, Gorsuch, and Barrett, dissented from the denial of cert. And he said plainly, if Yeshiva comes back to the Supreme Court, it's likely to win this case. In the wake of all of this, Yeshiva announced that it would decline to recognize any student groups whatsoever this fall, rather than be forced to recognize a group inconsistent with its beliefs. And that's one of the things that made the news that you might have seen. Ultimately, though, it has been able to strike an agreement with Pride Alliance to voluntarily stay the New York court's recognition order. So in other words, Pride Alliance has agreed, like, okay, no, you don't have to recognize us right away. Let's let this case continue to work its way through the appellate courts. So again, recall that Yeshiva was sued under a New York City law. So the specific legal analysis by which it lost in the first instance isn't necessarily broadly applicable. But the key question of federal law that Yeshiva brought to the Supreme Court, and that it probably will again if it continues to lose in New York, is whether the First Amendment prevents a city or a state from applying its laws in this way. Or is the application of the New York City human rights law in this way to yeshiva a violation of the First Amendment? That's an extremely important question for religious colleges and universities, no matter where they're located, because again, the question is, does the First Amendment protect you against a bad local law that's going to force you to act inconsistent with your religious beliefs? So that's a really important case. The converse scenario is also really interesting and has generated a fair amount of litigation in the last few years. And that question is whether a secular university can decline to recognize a religious student group because the university disagrees with the student group's requirements of its student leadership, for example. So one key case on this front came out of the University of Iowa, which about 5 years ago kicked Business Leaders in Christ, a student group called Business Leaders in Christ, kicked them off campus, literally and figuratively, declined to recognize them, wouldn't let them use any university student org's money, they couldn't meet on campus, et cetera, because the university said that Blink's requirements for its student leadership violated the school's anti-discrimination policies. Blink sued the school, and the federal district court said to the university, basically, you can't do that. You have to let Blink back on campus. So that was a great win. This type of fact pattern continues to come up. Just a couple of months ago, the Ninth Circuit issued a similar ruling protecting a Fellowship of Christian Athletes chapter in a public high school setting. And these cases will likely continue to come up. So seeing this pattern, the Trump administration, of which I was a part, I worked on the domestic policy team in the White House during the Trump administration. We tracked situations like this closely, and the Trump administration finalized a regulation in late 2020 that requires public colleges and universities to basically just to comply with the First Amendment guarantees of free exercise, free speech, and expressive association. And if a public college or university doesn't do that, by, for example, penalizing a student group for its traditional religious beliefs, then that university will be vulnerable to losing its federal funding from the Department of Education. And that would be a really big deal for a public college or university, really for almost any college or university. The department now, under the governance of the Biden administration, of course, said last year, it issued a press release saying that it's taking a close look at this rule and will likely rescind it. They haven't published a proposal yet, but keep an eye out for regulatory action on that front about student groups and how universities relate to student groups.
No,
and then, sorry, Michael, go ahead.
Oh, no, I was just agreeing with you.
Yeah. All right. So finally, it's hard to talk about higher ed without talking about Title IX. So we're going to talk a little bit about Title IX. Title IX is the federal statute, of course, that prohibits sex discrimination in education. The statute turned 50 years old this summer to much fanfare. So I'm guessing you all probably saw some news coverage about what it's done for women and what it does, what it continues to do. Title IX has a lot of tentacles, I guess you could say. It governs equity in athletics, of course, governs the handling of sexual harassment situations on campus and sexual assault situations on campus, and generally just, prohibits discrimination on the basis of sex in education. The statute does have a religious exemption in it, which says that it doesn't apply to an educational institution controlled by a religious organization if applying Title IX would be inconsistent with the organization's religious tenets. And importantly, because this exemption is in the statute, it's not a creature of regulation, the administrative state can't get rid of it, right? That you can't cancel a statute by regulation. So this is a really important and really strong legal protection for religious colleges and universities. And that's particularly true after Bostock, right? When the federal government and the current administration and a handful of courts have said that Bostock reasoning applies in the Title IX context as well, meaning that Title IX prohibits discrimination in education on the basis of sexual orientation and gender identity. Note that the courts are not so far unanimous on this, so don't let anyone tell you otherwise. Just last week, actually, for example, a federal district court in Texas declined to export Bostock's reasoning to Title IX, but it's certainly a pattern, and this administration has certainly taken that view. So although the Department of Education can't get rid of the Title IX religious exemption via regulation, it can, and I think it probably will, attempt to implement some limits on which institutions qualify for the exemption. So remember, the statutory language is you can take advantage of this exemption if you are, quote, controlled by a religious organization, And as with so many statutes, as you've all probably learned in law school, there is some really important and unfortunate ambiguity in that phrase, controlled by a religious organization. That is where rulemaking mischief can occur. The previous administration set really broad parameters by regulation in terms of how to determine which schools can invoke the exemption, right? So what does it mean to be controlled by a religious organization? The Trump administration regulation on that phrase laid out several different pathways to showing that you're controlled by a religious organization. I expect that the current administration will probably walk back those broad parameters and put in place narrower ones. However, interestingly enough, the department did not touch this issue in the Title IX NPRM it issued earlier this summer. So my expectation is that they're going to tackle this aspect of Title IX in the same regulation that they're going to use to roll back the requirements about how public universities can interact with their religious student groups. So that's another thing to keep an eye on. Then meanwhile, at the same time, on the litigation side, the constitutionality of the Title IX religious exemption is being challenged in federal district court in the case Michael mentioned, a case in Oregon called Hunter versus Department of Education. The plaintiffs in that case are a whole bunch of students or former students at religious colleges and universities. And they say that the Department of Education's recognition of the Title IX religious exemption violates the Constitution. So far, the Biden administration is defending the constitutionality of the exemption, but there's an interesting dynamic in this litigation. Earlier in the litigation, the administration submitted a filing saying that it planned to, among other things, that it planned to, quote, vigorously defend the Title IX religious exemption. They were trying to fend off would-be interveners, some groups who had asked the court, please let us into the case so that we can defend the constitutionality of the Title IX exemption in case the government doesn't do it. The Biden administration was saying, like, we've got this covered. We don't need interveners. We're going to vigorously defend the exemption. Well, the next day it withdrew that brief and filed a new version that took out the word vigorously and made some other discreet, but with probably significant changes. And this was after 24 hours of just being pummeled in the news and probably privately by some of their progressive allies for being too enthusiastic about the religious exemption. The backtracking at that point by the federal government was really something to behold. And shows you, again, it's a very sensitive and charged topic. This judge in Oregon is taking her sweet time, and she still hasn't ruled on the preliminary injunction motion that was argued a full year ago, last year in November. But keep an eye out for a ruling in this case. It'll make news too. This litigation, I think, like all of these issues, hopefully you think like maybe some of them, I just think is so fascinating because it's both culturally relevant and timely, right? These are hot topics, truly, but also legally really interesting because a lot of these issues are kind of like at the forefront of how to apply certain legal doctrines in a different context than they've been applied before, or sort of different twists on previous decisions. So there's some really cutting edge legal stuff here, as well as, again, sort of newsworthy, really interesting, culturally hot topics.
Yeah, no, absolutely. I couldn't agree with that more. Being able to take the different angles of it is definitely amazing to do with these topics. I know we're running a little bit short on time, so I'll ask this last question about the university-student relationship, and then we'll move in and see if we can do some Q&A from the audience quick.
Great.
So probably the only case that I think was talked about slightly less than Dobbs amongst my friend group in law school was the Kennedy decision last spring. I know that it's not quite analogous, given that it was a high school football coach, not necessarily a higher education. But we saw the Supreme Court's willingness to defend the football coach's religious expression. In your view, is that kind of defense with this makeup of the court likely to extend to these universities in the coming, whether it's Yeshiva or Hunter?
Yeah. Yes, absolutely. And that's a super astute question and a really good connection to make. So the answer is yes. This court has really shown itself to be full of free exercise hawks. You might even say free exercise maximalists in the case of some of these justices. And they've shown this over and over again, just even in the last couple of years. You don't even have to go very far back from the Kennedy decision you mentioned, Michael, to the Fulton decision last year, which involved the right of a Catholic child placement agency to decline to place children with same-sex couples, to the series of COVID worship cases where the court just repeatedly struck down state and local limitations on religious gatherings during COVID. Now, none of that was done in a vacuum or just made up, right? Some folks accuse the justices, the conservative justice sometimes, of just being legislators from the bench, right? But no, all of these cases are applying free exercise precedents. They are. But the bottom line really is that there's a majority, and in some of these cases, a supermajority currently on the court that reads those free exercise precedents and reads the First Amendment as providing a great deal of freedom to religious people and institutions. So I do believe that religious universities are ultimately likely to prevail in the Supreme Court on a number of these issues. They'll probably lose a lot of them in the lower courts, as we've seen in the issues I've been talking about tonight. But I think the Supreme Court is going to backstop religious institutions, including religious higher ed, on a number of these issues. But it takes a while to get to the Supreme Court and win that victory, obviously. And in the meantime, these are, again, I think, really fun issues to watch as they develop. So I hope you'll all agree. There might even be a student note topic or two in here for folks who are interested in this kind of thing. And many thanks. I'm happy to take questions.
I do not see any questions, so I'm actually a little bit thankful because it made you available to give a fuller response to that, and I greatly appreciate that. So we are running up against the end of the time, so just kind of quickly, I'd like to thank Jennie for your time. That was an amazing discussion. It was great to be a part of. I want to thank the Federalist Society for putting this whole study break series together. I think it's a great series that allows the practice group professionals and student chapter leaders to interact in a way that we normally wouldn't really be able to without this series. So thank you for that. I'd like to point out the next week's topic is communication law, talking about a question about internet for all. So the telecommunications and electronic media practice group and the University of Michigan Law Student Chapter will be putting that on. And I'm sure that that's just going to be another extraordinary discussion. So thank you everybody for watching. It was a pleasure to be here tonight. Again, Jennie, thank you so much and have a great night.
Thank you all.